Thank you for the introduction. Thank you for the invitation to the Board of Directors of the ACELC. It's a privilege to be here. I think this may be the first time that confessional Lutherans have met in the South. Now, I mentioned that to one of the guys as I was walking in. He said, well, we met in Texas last year or the year before. I said, that doesn't count. This is the South, folks. And I know a little bit about that because my grandmother was born in Sevier County, which is where Gatlinburg Pigeon Forge is, if you all know where that is. If you go from Knoxville and head toward the Great Smoky National Park, it's a hills and hollers area. Well, all my relatives on my dad's side come from over there, and I can't talk like that, but I'm trying. So if any of you from Tennessee, I got lots of roots. One of the pastors in my circuit has a cabin up there someplace, and he emailed me this week, I'm not kidding, and he said, you know there's a bunch of Nolands buried in the cemetery right near my cabin? I said, they're all over the place. I said, they've been there since the last war. He said, which war was that? I said, the one against King George III. I'm not kidding. So the Nolands and Delosiers and Heltons, they're all up there, real hillbillies. Originally, of course, a lot of those folks moved out, and part of Great Smoky National Park was designed to preserve their life and the evidence of it. And so if you've never been to that park, you really ought to do it. It's part of our national heritage. It's not that far away. If you don't have time this time, I'd suggest you take a trip there. Okay, the paper I'm presenting today, I'm not going to be able to read through all of it. I don't have time. But I think everything that's in there is important. So what I don't read, please do on your own time. I gave this to the Lutheran Concerns Association in January. I see a couple of you were there. I've added a few things since then. I haven't dropped too much out. So those that were there may note the new portions. So the title is Short History of the Discipline and Dispute Resolution System of the Lutheran Church Missouri Synod. Introduction. Political philosophy, that is also known as political theory, has been occupied throughout its history with two perennial concerns. The first is the restraint within a state of the chief executive or monarch, so that his actions promote the common good instead of his private interests. That, by the way, is why we had the Revolutionary War. The second is the administration of justice, so that offenses are properly punished, that conflicts between members of society are settled, and that due process is followed. In the history of the Lutheran Church Missouri Synod, the first concern of political philosophy was dealt with at its very beginning in the case of Bishop Martin Stephan. He was accused of using the financial goods and certain women of the Saxons for his own private interests. This led the founders of the Missouri Synod to establish a constitution in which the chief executive of the church was restrained by the synodical convention, as well as by other checks and balances. This was paralleled at the congregational level, so that the pastors of congregations were restrained by the voters' assemblies, as well as by other checks and balances. The second concern of political philosophy, that is the area of justice, has often been an afterthought in the Missouri Synod. Even today, at the congregational level, it is rare to find a constitution and bylaws that give much help to a president or elders attempting to adjudicate a case within a congregation. Just look at your own bylaws in your congregation. But we have always had a justice system of some sort at the synodical level. My essay intends to review the history of this system, how the Missouri Synod has dealt with offenses against its doctrine and moral standards, and how it settled conflicts when and where they occurred. Now, the next section, the prehistory, is something that's new because I came across a new resource, which is the Concordia Publishing House published the 1569 Church Order of Braunschweig-Wolfenbüttel, and this was authored by Martin Chemnitz and, Jakob Andrei. And so you can look there and see what was the typical organization of the Lutheran Church in Germany from the 16th century up until, up until the 20th century. This is what was typical for Germany. The Scandinavians had something else. But we should realize that when Walther and Company brought over the Lutheran faith, they often brought over the Lutheran polity with them. And so the roots of our ways of administering the church really go back to either this church order or something like it. We don't have time to study that today, but I recommend it for you, and I'm also recommending that our synodical president and his floor committees look at it too. And he has great interest in it because the opening essay is an essay that President Matthew Harrison wrote explaining the significance of that church order. Well, my essay is about the Missouri Synod, so let's go to the next section. Page 2, LCMS, first period, Conventions and Ad Hoc Committees. The heading there explains how we dealt with these issues. In the Synod's first constitution of 1847, the Synod president was given the responsibility of visiting in a 3-year period every congregation and pastor in order to review their doctrine, life, and performance of duties. He was to strictly follow detailed visitation instructions, they're called instructions, that were adopted by the Synod and published with the Constitution. As part of his visit, the president was to effect a peaceable settlement if there were differences between the pastor and the congregation. If there were other disputes between groups or individuals within a congregation, the president could also settle those cases, but only if all persons involved in the dispute requested arbitration. At the Synodical Convention, which was at first held annually, the Synod president was to report on his visitation from the previous year. If there was a case of a pastor who had continued in wrong doctrine or an offensive life, and the pastor had been reprimanded several times by the Synod president, the congregation involved, and the ministerium, that would be the pastors around his area, then the Synod president was supposed to report this to the Synodical Convention. On the basis of this report, the convention was to reprimand the offending pastor, and if this reprimand failed, the pastor was then to be expelled. In 1854, a new constitution was adopted by the Missouri Synod. The primary change was the creation of districts, initially 4 in number. The Synod president's duties of visiting congregations and pastors, the reporting of erring pastors, and the settlement of disputes were all handed over to the district presidents. Those duties have been with the district presidents ever since 1854. In those days and until the latter 20th century, district presidents were full-time pastors, not full-time executives as they are today. In the 1854 Constitution, cases of erring pastors were to be reported by the district presidents to their district conventions in the same manner in which the Synod president had handled those cases under the previous Constitution. The district conventions were to reprimand the erring and obstinate pastors and expel them if there was no change in response to the reprimand. Urgent cases of dispute within congregations were to be settled by the district president or by an ad hoc committee appointed by him. If the matter was not urgent, the case was to be settled by the district convention. The Synod president now had a different job. In the 1854 Constitution, he had the supervision over the doctrine, practice, and the respective administration of all church workers, all synod and district officers, the districts, the pastoral conferences, and the congregations of synod. But his supervision was severely limited to, quote, giving advice, admonition, and reproof, unless the affairs of the synod required his participation in a case, and he was expressly invested with such power. So this meant that when someone or some group went awry, the synod president could only report the problem to the district president or district convention. Finally, the case could be brought to the synod convention if necessary, but that convention always understood itself to be a final court of appeal. How did this work out in practice? Vice President Daniel Preuss published an illuminating article in the Epiphany 2003 issue of Logia titled Church Discipline in Early Missouri and Lutheran Identity. It is now available as a free download on the Logia website, and I recommend that you read it. In summary, Preuss states, quote, already by the 1870s, in view of the limited time available at the synodical and district conventions, investigations were handled mostly by committees. The final ruling, however, continued to be made by the synodical convention. As to the process of discipline or arbitration, those are two different things. Arbitration is you have two parties and they're fighting it out and you're trying to get them together again. Discipline has to do usually with the pastor or church worker who is either teaching incorrectly or has a moral failing. As to these processes, I assume that when C.F.W. Walther's Pastoral Theology was published in German in 1872, that its chapters on fraternal discipline, public repentance, and excommunication were used as a guide. And he there quotes from all sorts of stuff in Germany from centuries prior. For difficult cases, Walther referred the reader to the 1664 Wittenberg Councils and the 1623-1671 Treasury of Councils and Decisions edited by Georg Dedicanus. These books in Latin were collections of judicial decisions made by the Orthodox Lutheran faculties for church discipline and dispute cases in the 16th and 17th century. In 1902, August Grebner published an essay in English about the use of evidence in church discipline. That became part of John Fritz's Pastoral Theology in 1932. Fritz's work was still being used at LCMS seminaries and by LCMS pastors through the late 1980s, and some of the pastors here may have that on their shelf. I'm going to be skipping through the actual cases since the main thing we need to look at today is the process and the structure. So let's skip through to the end paragraph in that section. So that would be in the bottom of top of page 4, second paragraph. I give a couple of cases there. Again, you can read that later. In summary, the first period saw the administration of cases by district presidents, with the decision to expel or final decision in disputes being made by the district convention or synod convention. This entailed the use of ad hoc committees at the discretion of the district or synod presidents or by decision of the conventions. The LCMS second period, 1941 to 1971. This is when the Board of Appeals or Boards of Appeals were the structures that were used. The 1941 convention created permanent boards of appeals for both the districts and synod. The intent was to avoid the pitfalls of the ad hoc committee system and to keep most adjudicatory matters out of the synod and district conventions, which I think was a smart idea. And we have enough conflict in our conventions as it is. And cases are always conflictual by their very nature. The 1941's proceedings state, synod and each district shall elect a board of appeals, that of synod consisting of 4 clergymen and 3 laymen, and that of district of not fewer than 3 clergymen and 2 laymen. Their term of office shall be 6 years. No member shall serve on this board successively longer than 2 years. No administrative or executive official of synod or of any of its districts shall be a member of a board of appeals. End of quote. The prohibition of synod and district officials from serving on boards of appeals was in keeping with the American principle of the separation of executive and judicial powers. I think it was a good idea. It also spared synod and district officers from the type of backlash that President Fotenhauer had to endure due to his necessary and legitimate involvement in the Brooks case, which I detail in the previous section. The synodical president's powers in cases of adjudication or discipline changed significantly in 1941. Now we're talking about the synod president. Before 1941, if the synod had an erring district president, the synodical president was to deal with him, and if that proved fruitless, then he was to report it to the National Convention. And that process is still in place. You can see LCMS Constitution Article 11b-2. Before 1941, the Synodical Convention would then take up the case and decide what to do with that district president. In the revisions of 1941, nobody seemed to have noticed that the linkage between the two parts of the disciplinary process had been severed. Today, the synod president may still deal with an erring district president and report him to the synod convention. But the convention no longer has a process for dealing with the erring district president. It is like having policemen who can arrest but having no judge to bring the criminals to trial. The essential part of the justice system is missing, and therefore our district presidents are unaccountable since 1941. Think about that. Gene White, that wasn't in the LCA. It's something I found out since then. Keep working on it. So just think about it. Why has the Missouri Synod been since 1941, been going slowly but surely downhill? It's been in the district presidents, and they're not accountable to anybody except their own personal buddies within the district. There you go. You got stuff to work on there, folks. Okay, let's keep moving. The 1941 and 1971 bylaws, synod conventions could still review a case considered by the district or synod board of appeals by forming a committee of review. This committee, elected at the convention, was charged only with determining whether errors were made in procedure, and if so, the case was remanded back to the Synod Board of Appeals for correction. That's kind of like how it works at the civil court, where civil courts will review cases for procedural errors. In 1965, the Synod Convention gave to the district presidents the power to suspend a church worker from his duties and responsibilities of office before a Board of Appeals had determined that he was guilty. Does that make any sense? Now, this was a definite move toward an Episcopal system. Episcopal means that the district president serves like a bishop and he can cut you off at the knees or wherever he wants at any time. That's what a bishop does. And that did not sit well with the synod because we've never been Episcopal in that respect. The matter of restriction and suspension by district presidents was revised several times, 69, 71, 83, and 86. And then we go to the section that has the case about Pastor Otten. It is there for your reading. Now we're at the top of page 5, third paragraph. Into the LCMS third period, commissions on adjudication and appeals. In 1971, the Synod Convention revised the Board of Appeals system. Instead of 2, it created 3 types of judicatories: district commissions on adjudication, the Synodical Commission on Adjudication, and 3, the Synodical Commission on Appeals. The Synodical Commission on Adjudication was the venue for cases in which the synod, a district, or one of their agencies or employees was a party to a case. All members of these 3 commissions were to be elected by their respective convention, that is either district or synod. The adjudication boards consisted of 4 clergy and 3 laymen, at least 2 of which laymen were to be lawyers. The Commission on Appeals consisted of 5 clergy and 4 laymen, at least 2 of which were to be lawyers. The 1941 prohibition of synodical and district officers and staff serving on these commissions was continued with the exception of members of synodical seminaries and colleges. With the possibility of the review of cases by the Synod Convention via its Committee of Review, that possibility was eliminated in 1971. In other respects, the Commissions on Adjudication and Appeals operated in a similar manner as the previous Boards of Appeals. The difference between the two can be found by comparing the second period general rules governing Boards of Appeals with the third period rules of procedure. And then I get into the case of Robert Preuss. Actually, I think Rolf is going to be talking. Is it Rolf who's going to be talking about that? So you'll get some detail, but I've also laid out the essentials in this paper. Okay, please skip now to, let's see, it would be the top of page 6. LCMS fourth period, 1992 to 2004, the dispute resolution system. Now, when you all decided of the 10 errors that were wrong with the Missouri Synod, you really weren't saying that you were opposed to discipline in the church. Of all people, you're the ones that are most interested in discipline in the church. I know that. What you are opposed to is this system that was inaugurated in 1992. So let's see what it was. A committee called the Task Force on Conflict Resolution was appointed by President Bowman in January 1990 to review the entire system of adjudication and appeals. It should be observed that the Preuss case was uppermost in the Synod's president's mind at that time. The task force proposed a complete overhaul of the Synod's adjudicatory offices and procedures under the general principle of conflict resolution, which was then adopted at the 1992 convention. The preamble gave the rationale for these radical changes. I quote, "The process presented by the task force offers the Synod a new procedure for conflict resolution that is A, thoroughly biblical, B, stresses the reconciliation of members within the family of God, encouraging a win-win rather than win-lose resolution of conflict, C, presents a positive witness to the secular community as to how Christians resolve their conflicts, D, provides for final resolutions of disputes in a timely manner, E, is less costly in terms of money and time, F, discourages the secular approach of adversarial litigation, and G, requires a face-to-face meeting of the complainant and respondent in a spirit of Christian reconciliation." End of quote. Now, whether any of these statements are true, they were the selling points that convinced delegates to adopt the new system. In the new dispute resolution system, the previous prohibition of synodical and district officers and staff from serving as officers in the system was removed, as was the limitation of holding multiple offices. Reconcilers, who are really judges in many cases, were appointed in groups of 4, with no more than 2 pastors in each group. The requirement to have lawyers serving as adjudicatory officers that was found in the previous period, 71 to 92, was eliminated. And I remember at the convention people making arguments from the stage against lawyers in general. And the reason was to try to get that through. Dispute resolution panels at the synodical level were to include at least 1 pastor and 1 layman in a group of 3. The selection of the reconcilers was to be done by the district board of directors based on a list supplied by circuit counselors. The synodical dispute resolution panels were chosen from the total roster of reconcilers by casting lots. Now, I know this is throwing a lot at you because it's a very complex system and I can't go into all those details. I'm just kind of sketching it. There are many things that could be said about the problems inherent in this new system, and I think some of my co-presenters will be doing that today. I have only a few comments to make. First, in this system, there is confusion between dispute cases and expulsion cases in the bylaws, and that's in the period from 1992 to 2004. Second, the term reconciler is deceptive. Although reconciliation is appropriate where no harm has been done, restitution is also a Christian principle that needs to be observed where loss is suffered. Third, dispute resolution is a needed function and was part of the original LCMS visitation by the Synod President and later by district presidents. So we've been doing it theoretically all along. I can only guess that it was made part of the adjudication system because district presidents were no longer doing their job. Fourth, CTCR and CCM rulings, which are absolutely binding on cases in the dispute resolution system, are rendered ex parte. That's Latin, a legal term. That means without notice or hearing. So a case is being decided in which you have a lot to lose and you don't know what's going on. And you don't have a right to be there in your own defense or to have anybody else there. That's ex parte. It's absolutely contrary to due process. This principle of ex parte prevents these commissioners, it's on their side now, from understanding the full implications of what they're ruling on, and more importantly, denies to the defendants and complainants a fundamental right of due process. The ACELC recently discovered this when a ruling was made against them by the CCM without their being notified. Finally, lawyers and any sort of advisor are prohibited from attending hearings, so that both complainants and defendants are left to their own devices in church court. Those who are not knowledgeable in the law, whether civil or church law, could easily be taken advantage of by unscrupulous church officers or persons opposing them. Now, I give another case here. This is the David Benke case. Now, let's skip down to the current period, LCMS 5th period, the top of page 7. Dispute resolution system and hearing panels. In my opinion, the dispute resolution system did not handle the Benke case well, and not just because of its outcome. I think that the Synod President and his Blue Ribbon Task Force also came to the same conclusion, because they proposed another major revision to the adjudication system as soon as possible, that is to the 2004 convention. Although it had a number of faults, the system introduced in 2004 was an improvement because it separated cases that were disputes and that needed reconciliation from cases that were potential expulsions. The 2004 revisions to the bylaws also provided for a modified system for judging expulsion cases involving synod and district officers and staff, for cases in which the synod president is a defendant, and for cases of sexual misconduct or criminal behavior. I've analyzed the 2004 system as it presently exists in the 2013 Handbook of Synod in a flowchart that is available at the website of Brothers of John the Steadfast, and the web address is in your footnotes. So if you want to figure out, well, if I end up in this thing, where am I going to go? That flowchart might be able to be helpful to you. It is not unusual for LCMS people to hear about an erring pastor, teacher, professor, or congregation, and then wonder why the Synod President doesn't do anything about this. If the error happens at the parish level, involving a pastor, teacher, or commissioned church worker, or the congregation is to blame, according to the Constitution, the Synod President can do nothing about it, other than to tell the district president to go do something about it. See, the Synod President doesn't have jurisdiction at the local level. The district president can and has at times ignored the Synod President with impunity. This is the government that the Missouri Synod established in the 1854 revisions to our Constitution, and it has remained so ever since. A recent ruling of the Commission on Constitutional Matters confirms this. An important CCM ruling, check your footnotes on that one. The Synod President was also removed from supervision over the LCMS universities and colleges in 1995 when they were reincorporated as the Concordia University system. So they're also outside of his jurisdiction. Their faculty and presidents report to the COS board and its president. The Synod president now only has disciplinary authority over Synod officers, that would be like the treasurer, the vice president's secretary, employees of the Synod, actually under the umbrella of the Synod incorporation, districts as a corporation, and district presidents. That's it. But even with regard to these persons, the decision to dispel or expel, discipline or expel, is made by panels of district presidents and a reconciler. See the bylaws that I show you there. So the Synod president is only a first responder. He does not make final decisions in any of these cases. And if he knows who's on those panels that will be making those decisions, why is he going to start a case when he knows they're going to declare them innocent? So all he is a first responder. He does not have, since 2004, he doesn't have decision in the final case. In order to resolve the problem of the Synod president's weak to non-existent authority over erring district presidents, my congregation and others have memorialized the Synod with the overture, quote, to support proper ecclesiastical supervision in synodical districts. You can go to the footnote website and see what it says. This provides a process by which district presidents may be held accountable for their failure to exert doctrinal discipline and may be removed from office if and when the synodical president and the synodical convention both agree that this needs to be done. And that goes back to the way the Synod used to do it back before 1941. This will also prevent some districts from falling into the bad habit of doctrinal indifference. Finally, a word needs to be said about how the synodical and congregational adjudication systems work out in the civil courts. This is an addition now to my paper, but I think you need to know about some of these cases. 3 recent cases that pertain directly to the LCMS and how its congregations and church officers and pastors relate to the civil courts. What if a case ends up in the civil court? How will the civil court rule? The first is the 1985 appeals case, Whirling versus Grace Evangelical Lutheran Church of River Forest. Yes, that's the Grace Lutheran Church that you all know about. And finally, 85 is when it was finally that was the last appeal. In this case, the civil courts admitted they cannot determine whether the LCMS is congregational or hierarchical. The best lawyers in Chicago don't know what we're doing. Maybe we don't either. Therefore, the civil court cannot defer to the decisions of the Synod, its districts, or its church courts when Synod attempts to rule over a congregation. So basically they've said, we can't figure it out, so you're congregational. The second case is the 2012 Supreme Court case, Hosanna Tabor Evangelical Lutheran Church versus EEOC. You probably heard about that a couple years ago. In that case, which was considered a victory for religious freedom, the court decided that a congregation's right to choose its minister cannot be infringed upon by federal or state laws. Hey, that sounds good to me. Although a victory for the rights of congregations, it means that ministers of religion have little or no protection under federal or state laws when it comes to their employment, compensation, benefits, or similar matters. You get into the job, you should know that. You can't appeal to the state when it comes to all these laws that protect other workers. The third case is the 2015 case, Hillenbrand versus Christ Lutheran Church, Birch Run, Michigan. In this case, a pastor of a church who had served for 7 years was terminated by his congregation. He appealed to the LCMS dispute resolution process. And the LCMS dispute resolution process ordered that the pastor should be reinstated until he received and accepted a call to another congregation, and that the congregation who terminated him should give him back pay and compensation for benefit costs and trial costs. The congregation responded by terminating its membership in the synod, and they did not reinstate their former pastor. The civil court which heard the case determined that the LCMS is congregational. That says congregation. It should be congregational in its polity. That affirms what the Grace River Forest case said. This means that the synod is advisory with respect to congregations, even in adjudication cases. The court also determined that the only remedy available to the synod in such cases is to revoke the membership of a congregation. Dispute resolution panels or any church court cannot tell congregations in the LCMS whom or what they have to pay in damages or other forms of compensation. Furthermore, since the congregation had left the synod had no authority to bind the congregation under civil law. Now, I cannot advise you what these three civil court cases mean with respect to specific cases you or others might be involved with. I'm not trained in the law and I cannot advise in that area. I only bring these three cases to your attention because attorneys who are dealing with cases pertaining to the LCMS and its members need to pay attention to these three cases and to consider their merits as precedent in court. Conclusion. The LCMS now has a better system for settling disputes and for dealing with offenses than it did in its fourth period from 1992 to 2004. But this is a little consolation to those pastors and other church workers who were expelled from the synod, who were removed from their calls and livelihood, or who voluntarily left the synod because they were poorly treated in that period. The present system has its own faults, as the recent case of Professor Matthew Becker demonstrated. The Lutheran Concerns Association has offered an overture to the 2016 convention to appoint a new task force so that we may do better as a synod in treating our church workers and preserving the gospel among us. I encourage you to support that overture to synod through your delegates to our convention in Milwaukee in July 2016. Thank you very much for your attention.
I have not made it to all 509 pages of the workbook yet for synod, but I understand there are a lot more floor committees. Is there dispute resolution, any of them, any new committees? And in addition to the one in your congregation, not the resolution, the one overture your congregation did. Do you know if there are a lot of others? So that's kind of two questions. Is there a floor committee on this?
I have only briefly looked at the convention workbook, and starting after this paper today is when I'm going to start studying the convention workbook. They have, I believe, 15 to 20 floor committees. Normally they have about 10. There it goes. That's better. And so the idea is that this will give each floor committee more time instead of just brushing over something to deal with some of these issues. I believe there is something that deals, a floor committee that just deals in the area of adjudication and dispute resolution and that whole thing.
It's Floor Committee 12 on ecclesiastical supervision and dispute resolution. I'm going to mention some of them.
Good. Are you on the committee?
No. I am a delegate, though.
Okay. So yeah, there's your answer. Though it's considered of enough importance, and that means that there's enough overtures that went into the synod that the organizers, the synod president said we need to do that.
All right, thank you, Pastor Noland, for that detailed paper. I have a question. My congregation entered into dissented officially in 2005, going through the various stages, college of my peers, sending it up to CTCR, the district president, he's passed into glory. He said I was doing everything right, and the CTCR sent back in response to my dissent in 2006, as I was in 2008, and we went through that in Bible class, and my congregation, myself, we both sent back and said, we don't recognize this. We don't agree. We don't think we've been refuted, and we continue our dissent. My question is, are we in a dispute resolution process?
From what you've described, you're under bylaw 1.8, which is a separate thing.
Okay?
It's called doctrinal dissent. Is that what you do? Has nothing to do with dispute resolution or expulsion case. So your case is dealt with under 1.8. And those that are unfamiliar with it, the dissent is, goes to the Fellowship of Peers.
Right? And we did that.
And then to the CTCR.
In which he did that, and then the Will Robbery said in 2011, when he chastised us for not following this doctrinal dissent, and I said, hey, I've been waiting for an answer since 2008. He says, send me all the paperwork, and I'll see what I can do. I haven't heard from him since.
Yeah. So you dissent, then it finds expression as an overture to the convention calling for revision or rescission.
And we have done that. And they don't even make it to the floor committee, as I was out before. So that's...
That is the process, and so you've gone as far as you can go. You bring it to the intention, but it does not require that they respond.
Next question.
I believe you said that you thought the 2004 revisions were an improvement over the 1992 process. I'd like you to review why that you think that is, because I think in some ways it was gotten worse. Because now a complainant has to get the green light from his DP in order to have a case go forward, thus cutting off the possibility of what was complaints that were filed against Banky. So why do you think there was something improved about 2004 given that point?
Yeah, I understand the question, and it was in the paper that there was a confusion from 1992 to 2004 in what was a dispute resolution or expulsion. And so, in other words, let's say you have a problem with your pastor or with something's going on in the synod. The first question you ask is this something that's going to lead to expulsion or could lead to expulsion of the minister? If it's something that's going to lead or could lead to the expulsion of the minister, then it goes into the expulsion process. And I'm using that as my own terminology because the terminology is all fouled up. And then if it doesn't have to do with the pastor getting kicked out of synod, that's expulsion, but it has to do with it could mean that he's expelled from his congregation but not from the synod. Then that is in the dispute resolution area. And so, but from 1992 to 2004, that was not clarified. And so everybody that was going to end up in the expulsion process had to go through the dispute resolution process. I mean, does that make any sense? No, it doesn't make any sense. I mean, because if I have a dispute with you, Pastor Hendrickson, let's sit down and work it out. But if you're teaching millennial teaching and that Jesus is going to come back when your Honda is parked in your garage, it's time for you to go out of the Missouri Synod. I mean, you do not belong in the pulpit, and I will file charges against you and hopefully lead to your being removed. So those are two entirely different things. So and that was not clear. So you had a mishmash of ideas and principles and procedures from 92 to 2004. In 2004, they made that correction and they made a separation. So now if you have something that's simply a dispute, you go through the dispute, and that's the goal, which is reconciliation. If it's expulsion, then it's like a regular case. It's like a criminal case. So is he guilty or not? If he's guilty, he's out. If he's innocent, he's in. That's it. Now, but you're right, there were some new things added in there, and I don't know how they got in there that are not They're actually not good things that were added. And one of those was, as I mentioned in the paper, is that instead of the synodical president being the person that's calling the shots on a district president, now it's a panel of district presidents. So it's the panel of peers decides whether a district president is in or out, not the synodical president. Synodical president can only say, hey, I think there's a problem, and that's it. So if the district president's, if he's got a bunch of buddies, which they all do, I mean, that's what they're all about, their college of peers is what they call each other, you know, they're just not going to be held accountable. And that was a big problem, I think, that was added in 2004. A good thing in 2004 was when they added a separate section dealing with criminal behavior and sexual misconduct, because that also goes into the civil realm. And it needs to be dealt with in a way that doesn't conflict with the civil realm, but that we're cooperating with the state courts and their laws, and so it tries to do that. So that was a good thing. So it's a mix and match, but I think the main thing was at least the Senate again realized, it was President Kieschnick that appointed this committee that said there's something wrong here, and they figured it out. Oh yeah, you know, there's two different things going on. And in fact, it was in the, where was that? Yeah, it's in the first convention, or the first constitution of Synod. It's clear that that the district president is going around and settling disputes, which is dispute resolution. And then if there's a problem with the guy that's teaching false doctrine, that's a separate thing over here. So we were doing just fine until 92, and then we didn't know what we were doing. So thanks, good. But I mean, it doesn't mean that what we have is without its faults, and that's why these overtures are being presented, and the floor committee is there to work on this.
Reverend Bruce Lay from Holy Cross, Albany, Oregon. Appreciate you taking Dr. Noland. You mentioned that the revisions of 1941 brought out the reality that district presidents were no longer accountable. Are you the first to discover that, and if not, then whom and about when? This is the first time I've completely seen it written like this. So about when did that come about?
Well, I'm saying that since the two, what year did you say?
1941.
1941, yeah. Yeah, that was an insight that it was during the panel, were you there at the LCA conference? And the LCA had the entire thing wasn't on this too, was it?
Everything but the creation.
Except the creation. So the LCA in January in Fort Wayne, they also talked about this. Most of their presentations were about this issue. And at the end, they had, I was the youngest of the group, Walter Disson, who used to be on the Commission on Appeals and could speak from experience, and David Hawk, who's been on the board of directors of the Synod. Boy, he is a sharp lawyer. So we had two lawyers, and I forgot who, Bill Kilps, who is going to make the presentation. Is he here yet? He was speaking on the reconcilers. And so we had a Q&A with two lawyers and two Missouri Synod pastors, and we just talked about this. And as we were going through, some lights went on in my mind about how the 1941 had a disconnect. That's when it happened. I think it was because of something Walter Disson said. He's kind of like the Holy Spirit. I listen to him very carefully, and I think about it, and I think, well, that really is true. And he's a lawyer, too. A great gift to our church that we've had lawyers like him. Another thing I should tell you is that the rules for procedure in that period from, up until 92, the rules for procedure were written by lawyers. Because when you hire a lawyer to represent you, what you're hiring is somebody who knows procedure. You know nothing about procedure when you go into civil court. That's what they're expert in. And you know about your own problems and you're trying to settle that, but you don't know how to go about it. The lawyer knows procedure. And so we utilized the talent that the Lord gave to us with lawyers, and they wrote the procedure for the Missouri Synod until 92, and then we tanked the whole thing and said we don't want any lawyers at all. And now look what we have since. We have a bunch of pastors writing, well, what do I say? What you have is ministers of the gospel trying to write law. Missouri Synod pastors we're geared toward gospel. We're not geared toward the law. So when we try to do it, it's a mix mash. It's a mix.
You made it very clear in your paper, Dr. Noland, that in many of these kind of things, the synodical president just doesn't have the power that we think he should or that we want him to have. Why is it then that under the previous administration with President Kishnik, whenever there was a ruling that he didn't like, he found a way to come up with some synodical president power to call up the ruling for review and just kept redoing it and redoing it and redoing it until he got the answer he wanted. Now, was he a better master at the bylaws, handbook, and constitution? Did he choose to use power that was there that our current president is restraining himself from using? What would be your observation with regard to that?
My answer is 2 words. Will Sones. Do you hear affirmation back there? Do you all know who Will Sones is and was? Will Sones was the long-standing, I don't know if he was the chairman, but pretty much was the chairman of the Commission on Constitutional Matters. And he ended up, he was previously the Wyoming district president and was a very close friend and associate of Ralph Bowman. And when the dispute resolution process was instituted, I believe it was that year or thereabouts, Will ended up on the CCM and has been on the CCM until last year, I think. So how many years is that? 20, 30 years?
Forever.
And anybody coming onto the CCM had to deal with Will, and it was never really a happy process. When Bowman was president, he would appoint his own men that agreed with Will. When Kishnik was on that the same thing, Barry was unable to get, I think, maybe one person, but it didn't have an effect. It was only when Will became unable to serve, because he is of older age, that we finally have now, as of last year, a decent Commission on Constitutional Matters that people actually follow the bylaws. They don't invent things that you never heard of before. You have a Secretary of Synod that actually has always been trying to do that, and President Harrison wants to follow the bylaws too. So the question is, how did Kishnik and Bowman get away with it? Is because they had their man on that key commission, and that key commission would come up with all the one that you heard about was the ruling which said that Benke could get off free because Kishnik told him that he could go up and preach at the Yankee Stadium thing. So in other words, if your pastor says that it's okay for you to go out and, do whatever, to go steal a car, if your pastor says it's okay, then it's okay. That's what the CCM ruling basically said. Now, fortunately, a couple conventions ago, we revoked that, which was just, but guess who wrote that? That's Will Sones. He will go down in the history book. My history book is the bad man of the Missouri Synod for this generation, because he perverted a lot of stuff. But Bowman and Kishnik knew how to use him. Now, the problem is, if he can do that, somebody else can do it too. So we need to figure out some way, and the best way is to, in my opinion, to say that CCM and CTCR rulings are not binding, they're only advisory. And so when you have a court, we call it a panel now, with the judge is the one that has to make the decision. He can get the expert opinion, but he has to make the decision. And then you have something that really makes more sense. Right now, though, CCM and CTCR rulings are not only rendered ex parte, which meant that you all in ACELC found out you had been tried and found guilty, and you never knew that you were even being tried for this, right? Yeah, well, that's ex parte. You were the victims of that. CTCR and CCM, in my opinion, should only be advisory, and that would help a lot. Because we need to have the experts, no doubt about that. But should they be these secret judges that nobody knows about and that's perverting our bylaws and our scriptures, too, for that matter? So there you go.
Will Will Soames also was the author of the divine dismissal of called her name servants of the word, that horrific document that we looked at last year in Kansas City. He is the author of that. And so that's why that name may sound familiar to some of you.
Thank you, Clint.
Thank you,
Clint. Yeah,
Before
that
you
was
leave,
worth
Dr.
putting on the record, yes.